So good morning, everyone, and welcome back to our weekly webinar series. Over to Anil, sir.
Thank you, Ankit. So welcome to 114th episode of AAA Weekly Webinar Series. As usual, subject today is the very recent discussion paper released by IBBI. First, we thought that we will analyze the rights of operational creditors under resolution plan, and we started our study on that. But in between, we saw that this study paper was, in fact, a discussion paper was released on 10th of June 2024. And then we thought that it would be better that we do this time. And the next 115th webinar we will do on the rights of operational creditors under a resolution plan. So this discussion paper released by IBBI, and we are all supposed to give our views and suggestions on this. In fact, this discussion paper is also based on a lot of feedback which has gone to IBBI regarding the Regulation 40 capital B. Regulation 40 capital B of CIRP regulations, in fact, introduced the forms like IP1, CIRP1 to CIRP6. So these forms were introduced on 27th of November 2019. And then later on, CIRP 7 form was also introduced on 15th of March 21. And then after that, on July 14th, 21, CIRP 8 was also introduced. That was regarding reporting on the PUFE transactions. However, the CIRP 7, which was introduced on 15th of March 21, in fact, is a form which is required to be filled many times a month. So, because wherever any of the activity, any of the event which has not happened or delayed or still not happening, that form has to be filled. So, in total, there are lot many forms which were in fact required to be submitted. The feedback was that the dates were also varied. In a case where an insolvency professional is doing say 5 cases of CIRP, there would be a possibility that maybe 20 forms are required to be submitted in a month. And in case some CIRPs are somehow pending before any court, maybe stayed, or maybe the resolution plan is not approved, then also the form has to continue that something is pending, and every month these forms has to be submitted. So these feedback had gone to IBBI, and IBBI was also working very kind of eagerly to resolve this, and technically a different portal was being developed, how all this information can be collated, how the auto-populated data can also be used. That was also being done. So in fact, there was a meeting of it was Financial Stability and Development Council. A meeting was held on 8th of May 23, and it was advised that the regulators should adopt a focused approach to reduce the compliance burden on the members or on the fraternity where the regulator is regulating. Then, like the Indian Institute of Insolvency Professionals of ICAI, IIPI, also kind of constituted a committee on the instance of IBBI and how to remove the duplicacy and redundancy in the compliances by IPs. So that report was also submitted, and ultimately when we see the objective of this discussion paper, this reform is to reduce reducing the amount of information and data that the IPs currently need to submit, and the kind of number of times it is required to be submitted, at times to IPA and also at times to IBBI. Then the the deadlines for compliances, that actually is generating a lot of pressure, which is impacting the otherwise efficiency of the insolvency professionals, because see, their more focus is on whether this additional fee, which is levied under Regulation 40, capital B, sub-regulation 4 of CIRP regulations, like which is 500 rupees for even 1 day delay, and from 1 day to 30 days delay, it is 500 rupees is the late filing fee. And if the delay is more than a month, then this 500 rupees multiplied by the number of months, that is the filing fee. And this filing fee is the amount which the insolvency professional has to make payment from his own resources and cannot become CIRP cost. So therefore, the attention of the insolvency professionals were in fact more on the compliances like CIRP forms, and also looking into the timelines. So that was also noted that it is impacting the efficiency because of the pressures. And also, there are some information regarding the fee of professionals, regarding the CIRP cost, regarding the relationship with the CD. So all this information was also going to IPA, and it was also going to IBBI. So that was also a kind of requirement of kind of rationalizing all this. So therefore, on 10th of June 2024, IBBI released a discussion paper, and where all this is proposed to be regulated. It is the kind of rationalized, and the burden on the insolvency professional is likely to be reduced in a significant manner. Now, the scenario which is presently what we are supposed to do as an insolvency professional during CIRP cases, that like the IP1 is a form that we are supposed to submit whenever the IP is accepting an assignment. Means the accepting is whenever the consent is given. Now, when the consent is given, at that time the terms of engagement, the terms of consent is also supposed to be given. But what we have seen in many cases, that we have given the consent, but the banks and the financial institutions have decided not to go for the filing of an application under Section 7. So those consents are just piling up, and the banks have conducted their process of selecting a IP, but the process have not moved forward because the bank have started chasing the other options available, like one-time settlement, like assignment to ARCs, like assignment NARCL. So even enforcement of security interest. So therefore, nowadays the banks and financial institutions, they are in fact trying to use all the options. So they are also keeping the option of insolvency, and while they are also pursuing the possibilities of assignment to ARCs and also enforcement of security interest. So this IP1 form is presently, it is proposed to be dispensed with, so it is not required, and the kind of information which was sought by IBBI in this form is now merged in the one form which is now called CP1, that has been merged now with the CP1. So the information, some of the information has been merged into CP1. Now, when we see the existing legal framework, we also have CIRP1. This is all the information till issue of the public announcement. Then CIRP2, it basically is from the public announcement till the confirmation or replacement of the RP or the IRP. Then CIRP3 from the appointment of RP to the issue of information memorandum to the members of the COC. Then CIRP4 is from the issue of the information memorandum till the issue of the RFRP. Then the CIRP5 is the basically issue of RFRP till completion of CIRP, and CIRP6 is for the event specific. But the event specific is whenever there is any UFE transaction, whenever any interim finance is raised, whenever any commencement of insolvency resolution process of grunters is done, extension of CIRP period, premature closure of CIRP period, request for liquidation before completion of CIRP, non-implementation of the resolution plan. So these are various events where the CIRP 6 is supposed to be filed, and then the CIRP 7 is also supposed to be filed. And in case the public announcement is delayed, then we have to file CIRP 7 and mentioning the reasons. In case the appointment of RP is not made within 30 days, then in case the information memorandum is not released on time, RFRP is not released on time, then the CIRP is not completed within 180 days. So then the CIRP 7 is to be filed again and again for all the events in case these events are not completed. So for each event, a form has to be filed every month in case this kind of event specific date, in case this event is not completed. Then is the form CIRP 8, which is regarding the PUFE transactions. Now, what exactly has been done? What exactly has been done is the proposed one very important and very significant change that the IBBI have proposed is the merging all these forms, and one date in a month will become an important date, and on that one date all these forms are required to be submitted. Now the CIRP 1, first of all, IP 1, when we give a consent, that is proposed to be dropped, and the relevant details are submitted in the assignment portal. So that actually would be submitted in the assignment portal and other compliances. Then CIRP 1 and 2, that is merged with CP 1. A single form can be filled after constitution of COC. So the COC constitution, and after that one form can be filled. And then the CIRP 3 and 4, it is merged with CP2, and that is a single form which can be filled after issue of RFRP. So these 4 forms are merged into 2 forms. 4 forms are merged into 2 forms. And then is the CIRP 5. Now the CIRP 5 actually have been divided into 2 parts. It has become CP3A and CP3B. CP3A is when the resolution plan is approved by the COC and is submitted to adjudicating authority, then we have to file CP3A, and CP3B will capture all the details when the order for approval of the resolution plan is issued by the adjudicating authority. So 3A and 3B, basically the 3A would be about the resolution plan, and the CP3B would be about the entire process of approval of the resolution plan. And the CIRP 6, as we have explained, that is now merged in CIRP 5, so that is dropped, and the information which was required in CIRP form 6 is now being captured in some other forms. Now CIRP 7 is revamped into the CP5. Now the CP5 is it to be submitted at the end of month, and it will provide the status of the CIRP. The most important is the status of the CIRP, reasons for delay, if any, and update on the meetings held during the month. Then is this CIRP 8, which was the event kind of reporting, which was on PUFE. So CIRP 8 is now revamped into CP4. So there is CP1, that is the almost beginning of the CIRP. CP2, which is a mid-level, which is the issue of RFRP. CP3A is the approval of the resolution plan from COC. CP3B is the approval of the adjudicating authority on the resolution plan. And CP4 is the avoidance transaction. CP4 is the avoidance transaction, and CP5 is the status of CIRP. Status of CIRP. So in case we see, presently we have 9 forms, and now which is revamped into 6 forms. Why I am saying 6? Because it's CP1, CP2, CP3A, CP3B, CP4, CP5. So there are 6 forms now, as against 9, there are 6 forms. However, the most important change that we can see is the timelines. Timelines, see, the presently, every different CIRP would have different timelines, because in each CIRP, the date of commencement of the CIRP is different. So therefore, all the timelines under Regulation 40 capital A would be different. So that means that in case an IP is handling 5 cases, so all the timelines provided in Regulation 40 capital A, that would be different. So if that timeline would be different, so all the dates, all the due dates for filing from CIRP 1 to CIRP 8 would be different. So there may be a possibility that the insolvency professional is filing at least 1 or 2 forms every day, in case that particular IP is handling 5 cases or 6 cases. Now, what this streamlining has been done is very, very important. So all these due dates are not important. What is important is one important date, that is the 10th of every month. 10th of every month is the date where all the information as up to all the information up to the end of the last month. Like in case we are today, maybe if today is the 10th of June, then we are supposed to provide all the information to IBBI regarding that particular case up to 31st of May. So that is the forms, that is the most important convenience that has been, that is proposed to be given to the insolvency professionals, so that there is one date in a month which is a compliance date. Everyone can put it on calendar. Everyone can fill all the information, and most of the information will be auto-populated, because the IBBI actually, probably IBBI is trying to connect the portal with the portal of MCA, and maybe some other portals also, where the information will be populated automatically, and it will be also editable. So when I saw the forms, although the information is populated automatically regarding the name of the IP, the registration number, the address, the contact details, the email ID of the CD, the directors, the address of the CD, all this is auto-populated because of the integration of the IBBI website, IPA website, MCA website. So this actually is become very, very important. So what exactly is some monthly compliance reporting framework? That's called monthly compliance reporting. The status and the progress will have to be submitted on 10th of every following month. The only exception is CP3B, because the CP3B is the order of the adjudicating authority approving the resolution plan. That is something which is date specific, and all others are now not date specific. All other forms are the monthly compliance framework. Now, the monthly compliance framework is, in fact, the most important relief that we can actually see. Ankit, see, before I go to the detailed information which is required in these forms, would you like to add?
So only one question that has come in from Mr. Hari Prasad. He says, what about the penalties for not filing the forms by prescribed date? Are they waived, or they will continue? That's the question that he has.
But there is
That
no
may be.
proposal to change that regulation 40B sub regulation 4, which provides for the penalty of 500 rupees for a delay up to 1 month, and for another month, another 500, and for another month, other 500. So in case the delay is 10 months, then 5,000 rupees. And if the delay is between 1 day to 30 days, it is 500 rupees. Then the this Regulation 40 capital B, sub-regulation 5 also says that the action by IBBI will also be taken. That can be issue of SCN, or that can be even issue of the AFA, authorization for assignment. That also can be held because of various non-compliances under Regulation 40 capital B. So there is no proposal as of today to remove that penalty regulation.
Right. So I think that's about it. We should of course, this is a little simplification because everyone was talking about how this compliance is very rigid and rather it is too demanding. So I think this is a rejig with respect to all that, and I also understand that this is part of the preparation for the digitization of the entire framework. So as we know that IBBI is working on a platform, a digital platform where they will be able to kind of automate a lot of compliances through that portal, also have an integral system with NCLT and so on. So that framework will also perhaps use these forms or these documents. We've seen similar changes or similar revamp happening in MCA whenever the digitization happened or when the V3 compliance came in. So it also seems to be preparation on that account.
Mm-hmm. So, Ankit, I think let us see this form CP1, because I believe in case we share this screen, because like in case we are discussing the forms, it is better that our audience also should see the forms. So this is the CP1 form, and you also will kind of see that most of the information in the CP1 is auto-populated and also editable. So that is very important. That means name of the corporate debtor is auto-populated. That actually shows that the IBBI has kind of auto, what normally you say this like it is connected to the MCA website also. So whatever information is available on MCA website, that also comes automatically in these forms, automatically filled up. The SIN number, the PAN number. Now the PAN number and all that, I think that actually means that because I have never seen the PAN number on MCA website. Have you seen that PAN number on MCA website, Ankit, for any CD?
It's not necessarily linked with the MCA website. It is also sometimes linked with some kind of master data. So whenever we're creating a new corporate data, we are punching in some information with respect to that entity. So I believe that is the idea. So in case the PAN is available in some database that is master database for that CD, then it will auto-populate here. Otherwise, it will not.
But then the master data is not supposed to be populated by IP. It may be it will be
Master data is
populated by
created.
somebody else.
The master data will normally be updated based on various filings done by anyone. So let's say that you punch in, you fill it up a CP1, and there is you update it and you kind of edit it, and you then file it. So ideally, whenever you file this form, the software has a provision to update these databases with the default databases that you have just entered. So it is not necessary that it is being picked up from MCA. It can also be picked up from past filings.
So, like since the CP1 is the first form, so it is the first time IP is filling this form. So before this, there is no other form which is supposed to be filled up. So I am sure that this is actually, even the industry sector auto-populated means that it is something, some information is coming from.
Industry sector is linked with the SIN number of the company and also with the it is available with MCA. And the only thing that you said, the PAN number, maybe it is coming from some other source, not the MCA.
So again, this like address, registered email, name of the promoters has to be filled in, whether it's a going concern or not, whether the proceedings were pending against the, whether it was a SICA company or not, whether there was any application under the Companies Act regarding the winding up that was pending or not. Then regarding the insolvency professional, like all this information would be probably it would be auto-populated and also editable. Admission of the application by the IAA. So we are also supposed to file that the date of filing of the IAA application, that is something that we don't get from any source date of filing of the application before adjudicating authority, maybe under Section 7 or maybe under Section 9. That is very difficult to find. Of course, the bench applicant, address of the applicant, all this can be found. However, at times the address of the applicant is also not, because see, the order doesn't have that, and the copy of the petition is not available to the insolvency professional. So this information, how this information will be filled, if any of our audience can also add how this, like my understanding is not complete regarding how the PAN will come, how the date of filing of the application before the adjudicating authority, how that would be available with the insolvency professional. If any of the participants today can show some light, he can raise hand specifically to answer these doubts, regarding the even address of the applicant is not mentioned in the order. So, as like date of admission, date of order, date of receipt of the order, everything is okay. And then the public announcement, the reason for delay, then the class of creditors, all this information will be filled, and this is the form where CP1. Then CP2 is again to be again 10th of every month, and that will be like in case the date of issue of the RFRP, and by the end, in case we are taking the same example, that in case we are filling the information up to 31st of May, assuming today is 10th June, then in case we have issued RFRP to COC before 31st of May, then CP2 is required to be submitted. In case the within the month of May RFRP is not issued, then 10th of June CP2 would not be issued. Rather, it would be issued subsequent month in case the RFRP is issued in the month of June. So various details of valuation, valuer's appointment, information memorandum, the PRAs, and the RFRP, all these documents are also supposed to be attached. So this again is some kind. Today is the day when, Ankit, we actually have to seek the opinion from all our audience, like according to them, what are the difficulties that we should collectively report to IBBI as a feedback on discussion papers. So if they can, after we finish in another 5 minutes time, we will take the kind of views of everyone. Everyone should come up so that collectively we should submit our suggestions to IBBI. Again, this CP3A, it is again to be submitted by 10th of every month, and this will be the approval of the resolution plan by the committee of creditors, and all these dates, all this information probably is available with the IP, and whatever is being offered is also available. And so this is the sections available, like the information related to the in case this particular CP3A is also applicable in case the resolution plan is approved. And section 2 is for resolution plan, section 3 in case the liquidation resolution is approved. So these are the two kind of like in case a resolution plan is approved, then section 3 is not applicable, and section 4 is applicable regarding the closure of the CIRP for any other reason. So 3A is actually important for 3-4 reasons. One, when the resolution plan is approved and submitted to adjudicating authority. Two, when the liquidation decision has been taken by the COC and the application is filed. Three, whenever there is a premature closure of the CIRP, maybe 12A cases. So these are all the three, these are different sections, and that is something. Section 5 is regarding the common information, which is applicable to every three scenarios. Avoidance transaction is also mentioned here, but I'm sure when the 12A is the case, in the case of 12A, avoidance transaction would not be applicable. And then, of course, this is for the first time the information is being sought, number of employees, at the beginning of the CIRP, and this information is very important when we try to understand the provident fund dues, gratuity dues. So these informations are very, very important. Going to three, CP3B is the date of approval of the resolution plan or the liquidation application or the process closure or any other. So these are different sections: resolution plan, liquidation, closure. So this 3A, whatever we have filled in 3A, that will also get auto-populated in 3B. And this form also is okay. So CP4 is also like kind of every month, as we said, that every form that we have to file is on 10th of every month. But other than this, the approval of the resolution plan, which is CP3B, that has to be submitted. CP3B has to be submitted within 7 days of the approval of the resolution plan or the liquidation order or the process closure. That is 7 days from the, so otherwise everything is 10th of every month. Now CP4, as we see this buffet transactions, so CP4, we every detail about the buffet transaction, and that too even transaction wise, that is something which is to be submitted. And then we have CP5. CP5 is the again 10th of every month, and this has to be this is regarding the CP5 is regarding the stage of the CIRP, at what stage this form is, and every month capturing the status of the CIRP as on the last date of the previous month. If an IP demits the office, agar in case any IP demits the office, he will only inform up to the last date that he was controlling the company, he was an IP on the company, and probably this form is required to be submitted every month. And because this is the form which actually gives the status. So then we actually move on to the form. So these are all the forms that we have. Form 6. Ankit, now we can actually try to seek the various questions, or anyone who would like to say what should be the suggestions. What should be the suggestions? That's what I just want to see.
So let me, take up all the comments on the chat box first. Quickly, we can do that, and we will. I think we can answer only those queries which are relating to these form filings, and maybe skip the others so that we can have a more thorough discussion on this topic. So, question is that is there any date for Form 3B? That's the
7
question.
days from the date of the order,
Yeah.
maybe the order for approval of the resolution plan, maybe the order for the approval of the liquidation, or maybe the order for withdrawal of the process.
Right. Then we have Mr. Hari Prasad saying PUF transactions are normally not adjudicated within the closure of CRP period. They are pursued by resolution applicant FC and RP becomes so if it is not, if it is that, then that doesn't, that event does not arise. So therefore that's something we can't address. This is a practical issue which cannot be addressed in the forms. CP46 additional fields to be updated by IP when application is adjudicated upon adjudicated by AA. So additional rows to be added on each filing by RP. So this is what is a comment, and now this is a suggestion that can improve this form. But I'm sure that when it becomes a digital form, additional rows should be allowed, even if they're not proposed in
Yes,
the
additional
draft form.
rows are allowed in various, but
This
this
is
is
taken.
but this each form is for each corporate debtor. The insolvency professional cannot file one CP1 for all the companies. One form is for one assignment.
So then Mr. Cooker is asking what is the name of the website on which these forms will be submitted? Assets access will be provided to values also or not. So values don't need to submit these forms. These are required to be submitted by IPs,
Yes, yes.
and these are always IPs know that these are available on IBBI website after they log in into their portal. Hari Prasad ji says, sir, 3A, CP 3A, Section 2, date of submission of Form H, compliance certificate as per Regulation 39.4 of CRP regulations. Form H shall be submitted to AA along with the resolution plan. as the date of submission of resolution plan to the AA is already furnished in the form. This may be redundant. So he's saying that this additional filing perhaps is redundant because the date of submission of resolution plan to AA is already furnished in the form.
So 3A is the form which is required to be filled in for submission of resolution plan for approval of adjudicating authority.
So he's trying to say that there's some kind of duplication there, that that information is already available in some other way with the IBBI.
What is that other way? Because see, like IBBI is also trying to say that there are some information which is for the sake of creating a database and that will be auto-populated.
So
So that is not.
we need to maybe understand from Hari Prasad ji that where do you feel that there is a redundancy or there's a duplicacy of process? We're not able to understand that. Then CP3A, details of admitted claims, principal and interest are to be shown separately to collect and disseminate correct information. Bifurcation of principal and interest may be made by adding sub-columns of principal and interest in the following areas. Column claim displayed on CD master data and IBBA website. Annexure 3, list of claims submitted online to IBBA by RP, and Form C, claim form submitted by FCs.
So,
So
like, see, interest is sought separately. I think for various reasons, the IBBI is trying to make a database, like what is the haircut based on the principal amount and what is the haircut based on the total. So IBBI is trying to create a database specifically in those old cases where the outstanding is say 100 and the claim is for 500 only because of the number of
all
years that
the yeah,
passed.
there's also a lot of criticism with respect to liquidation, the claim value versus the realized value. So if once the interest comes out separately, there'll be data to say that yes, this percentage of the principal has been received, and this percentage of interest might not have been received. I think that's the idea. Then Ashwini ji is saying, I think IBBI will capture many master data, including PAN, while we create assignment. Yeah, so it will come from some source. I think we will understand that as things progress. Then any form in which the disputed claims are not admitted or partially admitted can be put in. So any disclosure in forms with respect to disputed claims is what he's saying. So disputed claims are anyways, at the claim stage in CARP, one is not required to adjudicate the disputes and all that. So I understand that
Like this
either
is
it is
as per
admitted
the
or not.
regulations, the IPs are supposed to provide information to all claimants in case their claims are not admitted, so that they can take appropriate legal action and they can go for any kind of remedy available. But IBBI is, so far I could understand, they are not asking information about those claims which were submitted and has not been admitted by the RP. That information is not yet sought by the IBBI.
Then Mr. Maharaj Kumar is saying, sir, it happens at times when the NDA is not submitted by COC for sharing IM. In such a situation, how to comply with the timeline? So if the timeline with respect to IM sharing with COC is not complied with because of COC not sharing the NDA, then that can be a reason for you to say that no, the IM was not shared with the COC and it is ready for sharing. I think that's the
Absolutely, that
about
is the
it.
reason. Because see, like if
Yeah.
there is any delay in that event, the delay in the event will not attract 500 rupees penalty or the filing of the form is delayed. Within the form, you can always say that IM was ready and this email was sent to these stakeholders, whoever they have not submitted their undertaking, confidentiality undertaking. So
Hmm.
therefore, the IM is not being shared with them.
Then, sir, CP2E, request for RFRP, whether RFRP requires any non-refundable deposit for submission of or along with resolution plan, yes or no? So
No.
CRP regulation 336B4 says that the request for resolution plan shall not require any non-refundable deposit for submission or along with resolution plan. Hence, the option yes shall not arise. So he says that. So this is more of a checklist kind of a system
It's
that
a
you are
checklist
making.
kind of a thing
Yeah,
that
this
it
is more
comes.
of a Yeah, more of that. One of those questions which come out when you are applying for a visa that has any criminal action happened against you. So you say no, but if you say yes, then it will maybe raise a red flag. So something like that. Then what about the cases where the cases have been resolved before January 2020? So those cases which are already resolved are no longer requiring any compliance per se. I think those compliances end. You furnish a final report and that ends, right?
Sorry?
Those cases where resolution has happened before January 2020. So those cases today there is no filing required from the RP or
No, no,
anyone's side.
nothing is required.
Nothing is required for completed cases.
Yes.
And in Form CP5, Section 6, cumulative cost disclosure to be given every month, whether this cost is approved by COC or actually incurred till last date of the preceding month. So the question is that in CP5 Section 6, whether it should be the approved cost or whether it is the cost which is actually incurred till the last date of the preceding month. What is the requirement here for cumulative cost
I believe
disclosure?
the total cost should be given, and in case there is any cost which has been incurred by the IP but has not been approved by the COC, that is rather more relevant. And the IBBI would like to get this information that you have incurred a cost, but the COC has not approved. How can you incur a cost without the approval of committee of
But
creditors?
CP5 has details with respect to how much is approved and how much is not approved. It
Mm,
doesn't have a breakup, right? The
doesn't have.
question is that should we put the approved one or should we approve the what is it,
I think
incurred
there
till
should
last
be
date?
some, I still feel that there should be some kind of reasons for writing notes.
Or maybe we can pass on this practical difficulty as one of the suggestions and seek
Mm.
the details with respect to. So in case there are certain expenses which the RP incurs and sometimes he gets them ratified in the next COC meeting, they don't have any specific approval, then those are the costs that will always be a differential here.
Yes, yes.
So thank you, Anil and Chalia ji, for sharing this one. Then another one is if RP had already filed existing forms, all these new forms to be filed with all details afresh to be filed. So they're saying that if we had filled all the old forms, these are supposed to be filed afresh. That's the question.
No,
Or these
I
or
believe when this regulation will finally be notified, at that time we will be able to see what is to be submitted for the existing companies.
transition provisions will also come in,
Transaction
right? Yeah,
transaction provision will also be given.
yeah.
My understanding is that since these forms are new and all this information is already available with the IPs, IBBI might even say that since they are shifting to a different database, they might even seek information from all the IPs, right, starting from CP1.
Hmm.
Why? Because see, then in that case, only their data would be complete. So their data has to be complete. It is very difficult to start a data in between. Because see, if there are 700 CIRP cases which are presently continuing, for all these 700 CIRP cases, there has to be a meaningful database. Otherwise, starting from today would not be meaningful. So the IBBI might even say that you have to fill in one time all information.
So then one comment is that in the IA of the NCLT order, memo of parties, address of parties will be there. So NCLT order will never have the address. I think you're
NCLT order
referring to
will
the
never give the
application.
addresses.
Application might have the address, and application might be available, might not be available to everyone.
Yes, yes.
Then Sanchit ji is saying that so monthly reporting framework requires IP or IP to submit all the relevant forms for all assignments by 10th of next month for each activity for the last month. Yeah, so I think that's what.
So
So
even
there are
in
different
case of
forms.
IPE,
Yeah,
these forms are supposed to be submitted by the partner
authorized
who is by the
signatory,
authorized partner,
authorized signatory, yeah, authorized
authorized
signatory.
signatory.
So that's about it. And now we have one raised hand, which is from Mr. Anchala. I will just ask him. I don't have the co-host rights today. You will have to give it to me.
Just done. Done.
So I have allowed you to talk. In case you can unmute yourself and share what you have to share, Mr. Anthala. I also have Sanchit ji, rather RK ji. I'm asking him to unmute as well. No. Okay.
I think we can conclude in case there is no further question, and because this is a small discussion paper, and we can only add that it is definitely much welcome kind of a discussion paper. The obligations on the insolvency professionals will actually come down, the stress will come down, and the compliance dates would be lesser in numbers now, because there will be only one date, uh, one which is a compliance date, which is 10th of every month. So that is the uh, very big takeaway from these discussion papers.
So I have asked Mr. Maraj Kumar ji to share his thoughts. He is just unmuted himself.
Uh,
Sorry, my bad.
Good afternoon,
Yeah.
Anil sir and Mr. Ankit. So far as regarding compliance and compliance to be made, so far as date of filing of CIP is concerned, that we can have from the council like representing the case.
No, see, our council, so you are trying to say that the council of the operational creditor or the financial creditor only?
Yes, sir.
And we only can request him that he should give us the date of filing.
Yes.
Otherwise, it is not available on public domain. That's what I want to say. So that, of course, we can get by sending an email to the lawyer. And how do we come to know who is the lawyer in this case? Because the lawyer's only names are written now. Because how do we come to know about the contacts of the lawyer? Because nowadays a lot of cases are coming directly from NCLT, and where we do not know even the applicant.
And only in some cases I find this correspondence from the advocate, where he advocate of the OC or the FC kind of shares the order with the RP or the liquidator who is appointed. It doesn't happen every time. Sometimes, this information that somebody has been appointed as RP or liquidator comes from totally different sources.
So can we make a request to the registry to provide the same?
A registry doesn't provide that. You are just making a request and then waiting for it, and the form has to be submitted within the timeline. But I
Registry, my experience with respect to registry is that registry also kind of sees that whether you're a party to the matter or not, and then there's a process for them to take some deposit and then seek some instruction to give you a copy. It's not very easy. This is my experience with the registry.
Not to give a copy, but at least like we could, come to know about the date of filing.
No, I think like we are only trying to seek the opinion of someone who actually has tried and successfully tried. So these many options, of course, anyone will try, but there is nothing which is the concrete option. You may apply to registry, you may apply to you may seek information from the lawyer. So that is all an effort, and whether the efforts will be effective or not, that we don't know. Because see, what we are trying to understand from everyone participating today, whether there is any information publicly available where we can go and fetch it.
See, there is still a duplication with regard to public announcement, which we have to upload on IBBI as well as IPA website. So we can give some suggestion on this recommendation to IBBI to avoid such duplication. And one more thing is that half yearly return which IPR to upload on IPA website, again there is some duplication of data. So if that half yearly return also information gets auto-populated.
So one is the half yearly return.
Yeah.
And the other that your recommendation is?
Public announcement, we have to upload on both the websites.
No, the public announcement when we, okay, it is required on both the websites.
Yes.
So another input. So another
Sir,
input that has come, another input that has come through the chat box is that the date of filing is available on NCLT website in the menu case history when you punch in the case number. So I think this is a public data that can be used by everyone. I think this kind of resolves this issue.
I'm not
Sir,
sure whether it is available. See,
Sir,
This has come from
maximum information are
this has come from about 5-6 people that this is available in case history when you punch in the IA number. From the NCLT website it is available. This is what everyone has said.
the case history means case history is even the date of filing is also available.
Yes, this is what everyone is saying. And this has come from 5-6-7 people. Yes, please
advocates'
continue.
names and all other information are available in the admission order also.
Names are available.
Anyway, so this is taken care of, that if it is available, then it is available. Yeah.
So even the names are available, then we'll actually find the whether this is okay in case the case history also
Case history is
captures
a
the date of filing.
case history date of filing is available. That kind of resolves this issue.
That resolves this issue.
Yeah. Any other comment from the people who have raised their hand? Else, then we will.
Monthly update which we have to
All
give.
informations are available in the admission order also.
No, in the admission order, the date
Of
of filing is
filing.
not available. And also the address of the advocate or email of the advocate is not available. Also the address of the corporate debtor is not available.
Sir, monthly update which we are required to do on IPA website, again there are some duplication.
Yes, that can
including creation of assignment at both the end. So if the assignment is created at IBBI mentioning the IPA name, then it should get auto information should go to the IPA.
I believe once this is notified, then the information which is required to be submitted to IPA and the IBBI will be one only. Because whatever this data will also be accessible by the IPA. This is my understanding. If someone else has a different understanding, I think that he can raise hand or he can write on the chat box. My understanding is that once this would be notified, this will be all information regarding with IPA as well as IBBI. Because see, the primary objective of this discussion paper is to remove the difficulty of submission of information or duplicacy to submission. Duplicate information is to be deleted.
So, since you're writing down the observations, one more observation that came in for CP5 section 6, that the cumulative cost disclosure, there might be a confusion with respect to whether to put approved cost or actual cost incurred till the last date of preceding month. And also there is a possibility that in case there is an interest, then filing, approved and unapproved expenses separately is also a possibility. I think with this we can wind up, and
Yes.
I think there is no other question that is left. So thank you so much for all the feedback that everyone has shared. This was extremely helpful, and looking forward to see you next week.
Thank you very much. This is our way of learning.